This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So today we want to talk about what it means to have live witnesses testify. We want to talk about, is it worthwhile going to the trouble and cost of having witnesses come to court and testify? And I think probably instinctively we all have a sense that seeing and hearing witnesses testify in person has some value, but it's difficult to have a really deep understanding of that without having the experience of sitting in many, many trials, watching many, many witnesses, comparing the impressions that witnesses make when they testify in person versus the impressions they may make through their written statements or even written testimony. So we can't give everyone that experience, but we're going to try and do the next best thing and ask three people who have had decades of experience dealing with witnesses, calling witnesses, examining witnesses at trial, hearing witnesses testify, and trying to determine whether witnesses are telling the truth. And we're going to ask them to share their experiences with you.
I was a prosecutor in the Manhattan DA's office for 5 years and the first assistant at the New York State Organized Crime Task Force for 9. But I've been a judge for 30 years and have presided over more than 400 felony criminal cases. I would guess in maybe 50 or 70 of those cases, they were bench trials where there was no jury. I was the finder of fact. But in the rest, they were jury trials, and the jury ultimately made the decision. But I've also presided over suppression hearings, and in those I was the finder of fact. So I've been called on to make credibility determinations in many, many, many cases.
I graduated from law school 40 years ago, almost to the date. I spent 15 years as a practitioner, including 5 years as a federal prosecutor trying criminal cases for the government in federal court. And for the last 27 years, I've been a United States magistrate judge, 9 of which I spent as the chief United States magistrate judge of our court. Like Judge Marcus, I've presided over fact-finding by the bench myself, as well as jury trials, but my experience as a judge has been more on the civil side, but not exclusively on the civil side.
I am a practicing lawyer and always have been. I've practiced law for about the same amount of time as Judge Gold, about 40 years. I've done this on the criminal side, from both sides of the table. I was a prosecutor for many years, a federal prosecutor here in New York. Then for the last about almost 30 years now, I've been a defense lawyer. So I've tried over 25 cases. On both sides, a mix of both sides of that. So I'm very familiar with the trial process, the credibility finding process, the preparation of witnesses, the cross-examination of witnesses. This is something that I love. I love to do it. I love to study it. And thankfully, I've been able to do quite a few fairly high-profile criminal cases on the defense side. And I've enjoyed that and learned a lot about witness credibility in the course of that.
Now we're going to show a brief excerpt from a well-known movie in order to illustrate how a witness's live in-court testimony can provide information that could not be captured by a written statement.
I would like to...
I have not quite finished. You are registered, are you not, under the National Health Insurance Act?
Aye, that's so. 4 and 6pence are paid every week. Och, that's a terrible lot of money for a working woman to pay.
I am sure that many agree with you. Now then, Miss Mackenzie, did you recently apply to the National Health Insurance for a hearing aid?
For what?
My lord, I must protest against the manner in which this question is being put.
I will repeat the question, my lord. I asked you in a normal tone of voice, audible to everyone in open court, did you apply to the National Health Insurance for a hearing aid?
Yes, I did.
Did you get it?
No, not yet.
However, you state that you walked past a door which is 4 inches of solid oak. You heard voices, and you are willing to swear that you could distinguish the voice of the prisoner, Leonard Vole.
Who?
No further questions.
That's a classic movie scene. It just demonstrates one aspect of hearing a witness testify in person versus reading a statement that the witness may have said that she heard something, but that there wasn't any examination of her ability to hear. So that's just a way to kick off our conversation. I'd like to ask each of our experts to just talk about their own opinions based on their own experience about the question of, is it worthwhile for you as a judge or a lawyer to actually hear the witnesses testify in person and to see them testify in court? And can you give us some actual examples from your experience for why that's valuable?
I have a couple of cases in mind, but generally speaking, of course, it's not only helpful, it's absolutely essential that witnesses appear to testify. That it's just critical to see them, to hear them, and to have their testimony subject to cross-examination in determining their credibility. As I said, a couple cases come to mind. One was a rape case that I tried a number of years ago, where the defense was consent. There was DNA evidence in the case, and there was no question about there being sexual intercourse, and so the issue was going to be consent. And the complaining witness who testified shattered that defense, basically by her appearance, by the manner of her testimony, her demeanor, her reaction to being questioned. All of that was readily apparent from her being there in the courtroom, and would not have been if it had just been a question of putting in statements or previous testimony that she had given.
Marty, can I interrupt you just for 1 second? I just wanted
Sure.
to ask you something.
Sure.
Oftentimes when people think about witnesses testifying in court and some of the value of that, they think about cross-examination and the opportunity for cross-examination and to challenge a witness. But the example you're giving us, it sounds like the direct testimony of the witness was really what impressed you to begin with, and that
Absolutely.
you wouldn't have gotten that same impression had you just read her statement.
Absolutely. Demeanor, demeanor is a tricky thing. Witnesses can be nervous, and sometimes nervousness is looked at as some indication that the witness isn't telling the truth. But on the other hand, just appearing in court and in front of a jury is something that causes people to be nervous and hesitate in giving answers. So there is some real careful evaluation that needs to be done. But the reaction to being questioned is an important part of evaluation of credibility. The other example I had in mind was a suppression hearing I did in which ultimately a weapon was seized in a car, but it began with a car stop and a police officer indicating that after the car was stopped, that he smelled marijuana in the car. And under our law, the smell of marijuana is a justification for the search of the car. So the lawfulness of the search turned on the smelling of the marijuana, and the critical issue in the suppression hearing was whether that was believable. And having a report that simply said, I stopped the car for this reason, and when I asked him to roll down his window. I smelled marijuana, plausible on its face. But when this is being presented in court, live testimony, and there is a need to tell the story, then many more facts have to be presented, and the questions arise about how was the marijuana packaged, where was it in the car, was it in the closed container, was it in the glove compartment, all those sorts of issues that make the credibility of the story turn on facts that are more detailed than what you might find in a written report. And once again, that's a situation where both on direct examination and cross-examination, issues about plausibility, believability will emerge.
Okay, so two great examples. I think just to underscore the point, it sounds like just the ability to get more details from the witness to back up the conclusions that they state in their written report is one of the values you get from having the witness testify in court. Particularly where the report is authored by someone, let's say in this situation, it's authored by a police officer who is the percipient witness, the witness who saw or heard whatever it is that's relevant to the factual determination, where that person is in control of what gets said and what doesn't get said in the report, having only the report and not having direct and cross-examination really limits what the fact finder finds out.
I was actually going to begin my remarks by saying that I come to the question of the value of live testimony with some humility, because I work in a system that adjudicates matters only based on live testimony, so I don't have that much experience with a different kind of approach. But as I thought about it, I decided that that's not quite accurate. Many times judges are called to issue orders in connection with matters that are not genuinely in dispute, and we do so often based upon the submission of affidavits or other documents that lay out the factual predicate for the issuance of the order without the kind of probing we would engage in when a matter is contested. And sometimes I've dealt with the very same issue, both as an uncontested matter with a factual record presented to the court on paper, and in other cases, the same issue is presented in a disputed manner at a live hearing with witnesses. And the degree of probing and evidence that can be brought out and the insights that can be drawn from it are really quite different. And it makes me wonder how many orders I issued on consent of the parties based upon a paper factual record that wouldn't really withstand scrutiny if the matter was contested and presented in a live evidentiary format. I can think of two examples of cases where I did confront live testimony that I think would have looked very different had it been submitted on paper. In one case, I was prosecuting the owner of a business for a tax fraud. And the key witness against the owners of the business was the bookkeeper who created the books and records that formed the basis of the fraudulent tax returns. And this bookkeeper embezzled money from the business while he worked there. And this bookkeeper originally told the prosecutors, including me, a version of the facts that turned out not to be accurate, and he was prosecuted with more serious charges for having misled the government in his first version of events. And I'm pretty convinced that if that written record were presented to a finder of fact without meeting the witness and questioning the witness, it would be hard to find beyond a reasonable doubt that the owners of the business were responsible for the tax fraud, as this bookkeeper said, and not that it was the bookkeeper's own con. In fact, the bookkeeper admitted that he filed false tax returns for all of the businesses where he ever worked. But when you met the bookkeeper and you saw the remorse that he exhibited, he actually broke down in tears when he was telling an anecdote that was relevant to the case, and his father came up. He broke down in tears about how ashamed his father would have been if he knew what he had done. And there was another point where he was explaining what he had done with the money he embezzled, and he admitted that he had gone to a house of prostitution and spent most of it there. And the shame and humility and lack of initiative and leadership that he demonstrated during his testimony, I think made it clear to everyone in the room that he would not have devised this massive tax fraud scheme on his own and without the guidance of the owners of the business who were the defendants at the trial. I had an opposite experience in another case where there was a claim of sexual assault. And the victim of the sexual assault was a longtime employee of the organization where she claimed a coworker had assaulted her. She described the assault in explicit detail, actually remembering where in the building it had occurred and which hand was used and what part of her body was touched. And the level of the detail was really quite impressive, and there was no reason to believe that this witness would have made up this story of sexual assault. But there came a time when, after her direct examination, during which she was quite forthcoming and responsive, she was questioned by the lawyer for the alleged perpetrator. And at that point, she became very angry, very defensive, said she didn't understand the questions even when they were clear. And it became quite obvious to everyone in the room that she was exaggerating greatly or completely lying about what had occurred. And so by seeing these people in person, we gained sort of a three-dimensional sense of who they were and what their motivations were that a paper presentation could only have provided in 2 dimensions. I think it was very valuable to the accuracy, or very helpful to the accuracy of the results that were reached.
So thanks, Steve. I think it's a great couple of points, particularly when you have an important witness, either a cooperating witness in a criminal prosecution or the victim or the perpetrator. You really get a sense of the person when you see them testify, something that you can't possibly get an accurate picture of just from reading what they say. And one of your examples, even though there was tremendous detail in the written record, you still didn't get a sense of the person until you actually saw her testify.
That's right. That's right. And I think we all can extrapolate from our personal experiences with coworkers that, or family members, that sometimes it's not what they say, but it is the way that they behave when they say it, or when you follow up with a question, particularly in a work setting, and some people are able to explain their responses and some people become defensive and you lose your confidence in what they have to offer you.
I fundamentally agree with everything that Judge Marcus and Judge Gold said. From my point of view, I can't think of anything more fundamental to the truth-seeking process than to have the witnesses present live in a courtroom, having to present their testimony and being subject to cross-examination. It seems very fundamental to me to the goal of determining the truth and making sure that the result of the proceeding is fair and just. In every case I've ever tried, there have always been significant issues for many witnesses as to whether their memories were accurate as to whether they were telling the truth, which are two separate questions. And that those subjects of accuracy and honesty, in my view, can only be probed live. If you're looking at a piece of paper with a statement from the witness, I don't think you can effectively determine the witness's capacity and ability to be accurate, and also whether the witness is trying to be accurate or is the witness lying. So I would say it's fundamental why the live testimony is so much more important. First of all, when you're looking at a statement, I think you have to analyze, you have to know what is the process through which this statement was obtained. Whose words are there in that statement? Is this the product of the witness, or is it really the product of a lawyer or a prosecutor who's talking to the witness and putting it in perhaps the lawyer's own words? So you'd need to know the process by which a statement was taken to understand whether it has a truthful power or not. And for that, you'd need to understand it from the witness. Second reason that I think live witnesses are so important is human memory is just fallible. It is imperfect, despite our best intentions. People see things through their own perspective at the time that they're observing an event. And then as years go by, that perspective changes, that memory changes. And so even if someone's trying to tell the truth, there are always significant questions about their ability to really remember accurately what they're describing. And that needs to be probed in examination. And the third thing is that people do, sadly, intentionally lie. It is not uncommon. I've had many, many trials where I've come to the view that a witness was lying. Frequently, there's a reason for that, a purpose, a motivation, but it's critical to be able to probe those three areas: the process of any statement that was given, the ability of the witness to give accurate testimony, and the question of the witness is whether the witness is attempting to tell the truth or has some reason to be lying in the proceeding. So I can think of a couple of examples that illustrate these kinds of things. In the last trial I had, it was the defendant was actually a prosecutor, a lawyer and a prosecutor who had worked for many years on the prosecution side of cases, and he was indicted, he was charged with obstructing justice in another case. And the lead witness against him was a police officer who essentially testified that the defendant had tried to influence the police officer's testimony in another case to help the defendant in that other case, who happened to be the chief of police. So the defendant was charged with obstructing justice by asking another witness essentially to lie in an unrelated proceeding. So the star witness was this police officer who claimed that he had been asked to lie. And what we learned before the trial was that about 3 weeks before he started his cooperation with the government, he had been hospitalized, and he had had hallucinations, he had had delusions. He was in the hospital for 5 days, where he imagined that there were children in his room selling him ice cream who did not exist. And so this was a tremendous question of what was his mental state a couple of weeks later when he began cooperating with the government and giving them the information that was ultimately used at trial. And this was a very subtle and delicate point. The government's position, the prosecutor's position, was that although this had happened, it was a short-lived episode, and the witness had recovered from it quickly and could be relied upon 2 weeks after to be accurate and precise. The defense's position was no, this was essentially a witness who'd had a nervous breakdown of sorts, and their mental state could not be relied on to be giving accurate information 2-3 weeks after that episode. So given the subtlety, the nuance of that issue, it could only really be determined live. You have to hear the witness explain what happened. You have to hear the defense cross-examine the witness and try to prove that this is very, very, very relevant and that the jury should discount that witness's testimony. And you have to hear the government argue, no, this was a short-lived event. They should not discount his testimony. But I think there's no way without a live witness having to answer those questions that you could do that. One other example comes to mind. Several years ago, I tried a case involving one of the largest frauds in U.S. history committed by someone who's famous here named Bernard Madoff. And it was a multi-billion-dollar fraud involving the fake trading of stocks. And my client was a computer programmer who was charged with, he worked for Madoff, and he was charged with designing the computer programs that helped Madoff carry out the stock fraud schemes. And in that case, the government's star witness was Madoff's number two. He's the number two person in the organization. He was Madoff's chief assistant. And that person was testifying essentially to try to get a lesser sentence. He had made a deal with the government that he would plead to somewhat lesser charges and would get credit for cooperating with the government in exchange for his testimony against a number of people, including my client, who was on trial. So that's another instance where that witness took the stand, told his version of the facts, which were very detrimental, harmful to my client. But the question was a couple of things. Number one, was that witness lying because he was trying to save himself? That is a classic question that I think can only be answered live by the witness being questioned. The government argued, no, he's telling the truth. Yes, he's trying to help himself, but he still can tell the truth. The defense argued, no, he's trying to help himself, and so he's shading the testimony. He's exaggerating it. He's making up details so that he can get more credit for his cooperation. That type of debate, I think, can only be determined by the jurors or the judge by hearing the witness live and really seeing, getting a feel for, are they telling the truth? Are they exaggerating? Or basically, can they be relied on or not? That's something that can't be determined from a piece of paper. Has to be done live, in my view.
I wanted to add something. It's not quite the same situation, but I think it's important and in a way illustrates the same point. And that is, it's become common in New York now, and it wasn't in the past, for the interrogation of defendants to be recorded when the interrogation is being done just by police officers. It's been done for a very long time where it's a prosecutor asking the questions, but for the police, it's the last maybe 5 or 10 years. And the difference between having a written statement by the defendant come into evidence and watching an interrogation that's video recorded that goes on for 20 minutes or 2 hours or 3 hours is night and day. And the ability to see the questioning process is so critical to evaluating whether the statement is coerced in some way and whether the statement is truthful or not. It's really critical to see the video itself and not just the written statement or even just testimony from the officer who conducted the interrogation as to what ultimately the defendant said.
I get from what you're saying that when you, as the finder of fact, get to see the recording, it makes a huge difference in your understanding of whether you should rely on the statement.
It does, and over time, it has begun to produce and will continue to produce more sophisticated judicial evaluations of what's permissible and not permissible in terms of the techniques that are used in interrogating witnesses or defendants.
In my experience, one of the most important things that's probed at trial is the process by which, if there is a witness who's been interviewed many times by the prosecutor, perhaps he's made a cooperation agreement with the prosecution, or he's just been interviewed many times. It's crucial at times to probe that process to see the degree to which the prosecutors may have influenced the witness's testimony, maybe not unlawfully, but subtly, suggesting facts, maybe giving them a hint as to what they really wanted the answer to be. There are a number of things that are frankly difficult to probe from a defense point of view at trial, but are very important to probe. And if the prosecutor were to know that those conversations would never see the light of day because no one would ever get to ask questions about them, I think there would be much more of a problem with prosecutors unduly influencing the witnesses. Prosecutors are worried about not going over the line because they know that whatever they're saying to the witness can come out on cross-examination. It might not, but it can.